What is a letter of credit? It is a written instrument whereby the writer, that is the bank, requests or authorizes the addressee to pay money or deliver goods to a third person and assumes responsibility for payment of debt, therefore, to the addressee. What is the independence principle in letters of credit? It means that in determining if the beneficiary of the letter of credit complied with it, the bank is required to examine only the documents presented. It is precluded from determining whether or not the beneficiary actually complied with the underlying contract. What is the exception to the independence principle in letters of credit transactions? Fraud exception rule. Fraudulent abuse of the credit. In case of collusion between the correspondent or paying bank and the exporter or seller of the goods, it is an exception to the independence principle. That is, the untruthfulness of a certificate accompanying a demand for payment under a letter of credit may qualify as fraud, sufficient to support an injunction against payment. What is the doctrine of strict compliance? The documents tendered by the seller or beneficiary must strictly conform to the terms of the letters of credit. That is, they must include all documents required by the letter of credit. Thus, a correspondent bank which departs from what has been stipulated in the letter of credit, as when it accepts a faulty tender, acts at its own risk and may not be able to recover from the buyer or the issuing bank, as the case may be. What is a warehouse lien? It is a lien over the goods deposited with him as his security for the payment of the charges, money advance, and other expenses owed to the warehouse man. Clearly, the lien exists for the benefit of the warehouse man. What are the remedies of a warehouse man having a valid lien against a person demanding the goods? The following are the remedies available to a warehouse man having a valid lien against the person demanding the goods: to refuse to deliver the goods until the lien is satisfied; 2. To cause the extrajudicial sale of the goods and apply the proceeds to the value of the lien; 3. By other means allowed by law, to a creditor against his debtor for the collection from the depositor of all the charges which the depositor has bound himself to pay; or other remedies allowed by law for the enforcement of lien against personal property. Can a bank refuse payment if the proper documents have been presented to it? The answer is no. The purpose of a commercial letter of credit is to ensure payment of a definite amount upon presentation of documents. The bank only deals with documents. It has nothing to do with the quality of the merchandise. Prudential Bank versus IAC. What are the three distinct and independent contracts in a letter of credit? SBL, sale between the seller and the buyer; 2, contract of buyer with issuing bank; and 3rd, the letter of credit itself, wherein the bank promises to pay pursuant to the terms and conditions of the letters of credit. This assures the seller of prompt payment independent of any breach of the main sales contract. What are the rights of the parties in a letter of credit? The person paying shall have the right to demand proof of identity of the person in whose favor the letter of credit was issued, and in case of non-payment, person to whom the letter of credit is addressed may institute an action involving execution. What are the obligations of the parties in a letter of credit? The drawer of the letter of credit is liable to the person on whom it was issued for the amount paid. In case of revocation, he must inform the bearer and the person to whom it is addressed. The bearer of the letter of credit will pay the amount received without delay. Notifying bank to notify and or transmit the documentary of credit to the seller beneficiary and assumes no liability. Negotiating bank buys or discounts a draft under the letter of credit. Liability depends upon the negotiation. Before negotiation, it has no liability with respect to the seller, but after negotiation, there is a contractual relationship prevailing between the negotiating and the seller. Confirming bank assumes a direct obligation to the seller. Distinguish the liabilities of a notifying bank, a negotiating bank, and a confirming bank. A notifying bank undertakes to inform the seller beneficiary that a letter of credit exists. Its obligation is limited to this duty and assumes no liability to pay under the letter of credit. A negotiating bank purchases drafts at a discount from the seller beneficiary and presents them to the issuing bank for payment. Prior to negotiation, a negotiating bank has no obligation, but a contractual relationship between the negotiating bank and the seller beneficiary arises when or only after the negotiating bank purchases or discounts the draft. The confirming bank confirms that the letter of credit will be honored by the issuing bank. A confirming bank, by such confirmation, ensures that the letter of credit will be paid in accordance with its terms. It therefore assumes a direct obligation to the seller beneficiary. What is a trust receipt transaction? It is a transaction by and between the entrustor and the entrustee, where the entrustor, who owns and holds absolute title or to security interest over certain specified goods, documents, or instruments, releases the same to the possession of the entrustee upon the latter's execution and delivery to the entrustor and the trust receipt. The nature of a trust receipt transaction is inconsistent with that of an assignment of credit, as the latter necessarily involves an absolute conveyance of title. What are the rights of the entrustor? They are entitled to the proceeds from the sale of goods, documents, or instruments. They are entitled to the return of goods, etc., in case of non-sale. They are to enforce all other rights conferred to him under the trust receipt law, and to cancel the trust, take possession of the goods or instruments or proceeds realized therefrom upon the default of the entrustee. They are to sell the goods in a public or private sale upon notice to the entrustee in case of default. They may also purchase at the intended public sale. The extent of security as against innocent purchaser for value not preferred, as against creditors of the entrustee preferred. What are the liabilities of the entrustor in any sale or contract made by the entrustee? The entrustor is not responsible as principal or as vendor under any sale or contract to sell made by the entrustee by virtue of such interest or having given the entrustee the liberty to sell or otherwise dispose of the goods, documents, or instruments under the terms of the trust receipt transaction. Thus, the repossession of the goods under the trust receipt suffice to satisfy the principal loan obligation? No. The entrustee remains liable for the deficiency after the proceeds of the sale have been applied to the payment of expenses and debt. What acts or omissions of the entrustee would constitute estafa, MAD? M. Misappropriation of the proceeds of the goods involved, non-payment of the amount involved, and failure to deliver proceeds of sale or to return the goods not sold. Who bears the risk of loss of the goods under a trust receipt transaction? The entrustee. What is the liability of the president of a corporation who signs a guarantee clause under a trust receipt in his personal capacity? He is liable personally and solidarily for the obligations of the trust receipt by signing the guarantee clause in his personal capacity. Can a trust receipt transaction involve goods which the parties know are not returnable to the trustee or to the trustor? No. When both parties enter into an agreement knowing that the return of the goods subject to the trust receipt is not possible, it is not a trust receipt transaction. The transaction becomes a mere loan where the supposed trustee's only obligation is to return the proceeds of the sale of the goods subject to the trust receipt. G applied for and was granted by BPI a regular credit line with trust receipts as collateral. G submitted a list of their assets in support of her credit application for participation in the special credit scheme. G signed a trust receipt, SCS, indicating the invoice number, quantity, value, and the names of the agriculture inputs she received upon the trust of PPI. When G failed to pay the obligation, PPI brought against G a complaint for the recovery of sum of money. Did the two transaction documents signed by G express the intent of the parties to establish a creditor-debtor relationship between G and PPI? Yes. The contract established a debtor-creditor relationship. The trust receipt was just collateral for the credit line. G signed the application for credit facilities, indicating that the trust receipt would serve as collateral for the credit line. G, as the dealer, signed the list of their assets that they tendered to PPI that reads, to support our credit application in connection with our participation to your special credit scheme. So G further signed the trust receipt, or SCS, documents defining her obligations under the agreement, and also the invoice pursuant to the agreement with PPI indicating her having received PPI products on various dates. The contract is labeled notwithstanding, thus was not a trust receipt transaction in legal contemplation or within the purview of the trust receipts law. Remedies available? What are the remedies available? Criminal. The failure of an entrustee to turn over the proceeds of the sale of the goods, documents, or instruments covered by a trust receipt to the extent of the amount owing to the entrustor or as appears in the trust receipt, or to return said goods, documents, or instruments if they were not sold or disposed of in accordance with the terms of the trust receipt, shall constitute the crime of estafa. In order to be validly prosecuted for estafa in relation to Section 13, they 1. Have the obligation to sell and remit the proceeds thereof to the entrustor, or return the goods, if not sold, misappropriated the goods and or the proceeds of the sale, letter C, performed such acts with abuse of confidence to the prejudice of the entrustor, and letter D, demand was made on the entrustee. Metropolitan Bank and Trust Company versus Jimmy Go and Benjamin Go, GR 155647. Another is civil. After commencing criminal action for violation of the trust receipts law, the entrustor may enforce civil liability arising out of the trust receipt in a separate civil action under Article 33 of the Civil Code. A civil action for damages entirely separate and distinct from the criminal action may be brought by the injured party in cases of defamation, fraud, and physical injuries. Estafa falls under fraud, and this is in the case of Prudential Bank versus IAC. Negotiable instruments law. What are the essential formal requisites of a negotiable instrument? We can use WS, UDON. W for must be in writing, signed by the maker door. S. U for contains an unconditional promise or order to pay a sum certain in money. D for payable on demand or at a fixed or determinable future time. O payable to order or to bearer, and N where it is a bill of exchange, the drawee must be named or otherwise indicated therein with reasonable certainty. Note, electronic messages like instructions given through electronic messages giving authority to debit a certain account are not negotiable instrument, as they do not comply with the requisites of negotiability under Section 1 of the Negotiable Instruments Law. What happens when any of the formal requisites are lacking? It is not negotiable, and the provisions of the Negotiable Instruments Law do not apply. The requirement that is lacking cannot be supplied by using a separate instrument in which that requirement appears. That's in the case of El Blanco Español, Filipino versus McKay. What is the effect if no date of maturity is specified in the instrument? It shall be payable upon demand. What is the effect of a conditional promise or order to pay? Answer: it is not a negotiable instrument, as it depends on a contingent event. What is the fictitious payer rule and who should be liable under it? As a rule, When the payee is fictitious or not intended to be the true recipient of the proceeds, the negotiable instrument is considered as a bearer instrument. In a fictitious payee situation, the drawee bank is absolved from liability and the drawer bears the loss. The underlying theory is that one cannot expect a fictitious payee to negotiate the check by placing his endorsement thereon. And since the drawer knew this limitation, he must have intended for the instrument to be negotiated by mere delivery. However, the drawee bank shall also become liable when it acts dishonestly and when it is a party to the fraud. PNB versus Rodriguez, GR 170325. What are the effects of a crossed check? We can use END. The check cannot be encashed but can only be deposited in the bank. It may be negotiated only once to one who has a bank account. And the D is it serves as a warning that the check was issued for a definite purpose, and the holder is not a holder in due course unless he inquired if he received it pursuant to that purpose. Bataan Cigar and Cigarette Factory versus Court of Appeals. Forgery and material alteration. Like, what are the effects of forgery? General rule, it is inoperative, hence no right to retain the instrument or give a discharge thereof or enforce payment thereof against any party thereto can be acquired through or under such signature. It is under Section 23. Who are the persons precluded from setting up the defense of forgery? 1. Those who, by their acts, silence, or negligence, are stopped from setting up the defense of forgery. 2. Those who warrant or admit the genuineness of the signatures in question, namely the endorsers, the acceptors, and persons negotiating by delivery. So what are the legal consequences when a drawee bank honors a forged check? In the case of a forged check, the drawee bank is considered as paying out of its own funds and cannot charge the amount so paid to the depositor. The drawee bank, however, can go against the collecting bank if the collecting bank endorses a check bearing a forged endorsement and presented it to the drawee bank. In this case, it is the collecting bank that guarantees all prior endorsements, including the forged endorsement itself. Therefore, the collecting bank is the one held ultimately liable. Traders Royal Bank versus Radio Philippine Network, GR 138510. What is the rule on the liability of signatories? General rule, only persons whose signatures appear on an instrument are liable thereon. A person whose signature does not appear on the instrument is not liable. Exceptions. 1. Where a duly authorized agent signs for a person, the latter is liable. 2. A forger is liable even if his signature does not appear thereon. Number 3. A person who is precluded from setting up forgery as a defense. And number 4. Acceptance of a bill of exchange is written on a piece of paper other than the bill itself. Unconditional promise in advance to accept a bill of exchange before it is drawn, which acceptance must be in writing. What are material alterations? We can use DST and CM. They are alterations that change the date, sum payable, time or place of payment, number of relations of parties, currency in which payment is to be made, or one which adds a place of payment where no place of payment is specified, and finally M, or any change or addition which alters the instrument in any material respect. What constitutes negotiation? An instrument is negotiated when it is transferred from one person to another in such manner as to constitute that transfer the holder thereof. If payable to bearer, it is negotiated by delivery. If payable to order, it is negotiated by the endorsement of the holder completed by delivery. What are the modes of negotiation of a negotiable instrument? Negotiation by delivery. Number 1. If the instrument is payable to bearer, then the instrument is negotiated by mere delivery. And a person in possession of an instrument payable to bearer is always the bearer thereof, and even if he has no legal right to it. Number 2, negotiation by endorsement. If the instrument is payable to order, two steps are needed to effect negotiation. 1, endorsement by the payee of the present holder, and 2, the delivery to the next holder. What constitutes an endorsement in instrument payable to order? It must be an endorsement of the entire instrument. A partial endorsement, or one which transfers the instrument to two or more endorsees severally, does not operate as a negotiation of the instrument. However, where the instrument has been paid in part, it may be endorsed as to the residue. Who is a holder in due course? One who has taken the instrument under the following conditions. Instrument is complete and regular upon its face. He became the holder of it before it was overdue and without notice that it had been previously dishonored, if such was the fact. He took it in good faith and for value. And finally, at the time it was negotiated to him, he had no notice of any infirmity in the instrument or defect in the title of the person negotiating it. Note, every holder is deemed prima facie to be a holder in due course. However, when it is shown that the title of any person who has negotiated the instrument was defective, the burden is on the holder to prove that he or some person under whom he claims acquired the title as holder in due course. This last mentioned rule does not apply in favor of a party who became bound on the instrument prior to the acquisition of the defective title. So what are the rights of a holder in due course? A holder in due course holds the instrument free from any defect of title or prior parties, free from defenses available to prior parties among themselves, and may enforce payment of the instrument for the full amount thereof against all parties liable thereon. What are the rights of a holder who is not a holder in due course? We can use OPID. He may sue in his own name, may receive payment, and if it is in due course, the instrument is discharged, holds the instrument subject to the same defenses as if it were non-negotiable. And finally, D, if he derives his title through a holder in due course and is not a party to any fraud or illegality thereto, has all the rights of such holder in due course. Can a payee be a holder in due course? Yes. Holder means the payee or endorsee of the bill or note who is in possession of it or the bearer thereof. Who are primarily liable in negotiable instrument? The maker in a promissory note and the acceptor in a bill of exchange. Who are secondary liable in a promissory note? The endorser, in a bill of exchange, the doer and the endorser. When is the presentment of payment required to be made? When it is not required. Presentment of payment is not necessary to charge persons primarily liable. It is required only to charge persons secondarily liable, except 1. As to the doer, where he has no right to expect or require that the dowee or acceptor will pay the instrument. And number 2, as to endorser, where the instrument was made or accepted for his accommodation and he has no reason to expect that the instrument will be paid if presented. When may presentment of payment be dispensed with? RFWD. Where after the exercise of reasonable diligence, presentment cannot be made. Where the dowee is a fictitious person. Number 3, by waiver of presentment express or implied. And finally, when the instrument has been dishonored by non-acceptance under Section 83. To whom must a notice of dishonor be given? General rule, a notice of dishonor due to non-acceptance of non-payment must be given to the drawer and to each endorser, otherwise there will be discharge from liability. Exceptions are WDDDIP. W. Waiver of notice of dishonor. Notice of dishonor is dispensed with. Notice of dishonor need not be given to the drawer. Drawer and drawee are the same person. Drawee is a fictitious person or a person not having capacity to contract. Drawer is the person to whom the instrument is presented for payment. Drawer has no right to expect or require that the drawee or acceptor will honor the instrument, and drawer has countermanded payment. Another one is notice of dishonor need not be given to the endorser when the drawee is a fictitious person or person not having capacity to contract, and the endorser is aware of that fact at the time he endorsed the instrument, or the endorser is the person to whom the instrument is presented for payment and instrument was made or accepted for endorser's accommodation. Another, when due notice of dishonor by non-acceptance has previously been given, a subsequent notice of dishonor by non-payment need not be given. When omission to give a notice of dishonor by non-acceptance does not prejudice the right of a holder in due course subsequent to the omission. Note, the drawee is not liable until he accepts the bill. How is a negotiable instrument discharged? By payment in due course by or on behalf of the principal debtor. By payment in due course by the party accommodated where the instrument is made or accepted for his accommodation. By the intentional cancellation thereof by the holder. By any other act which will discharge a simple contract for the payment of money. When the principal debtor becomes the holder of the instrument at or after maturity in his own right. What is acceptance and what are its requisites? Acceptance is the signification by the drawee of his assent to the order of the drawer. It is an act by which a person on whom the BOE is drawn assents to the request of the drawer to pay it. Its requisites are, must be in writing, signed by the drawee, must not express that the drawee will perform his promise by any other means than payment of money, and communicated or delivered to the holder. We can use WSEC. What is a promissory note? A promissory note is an unconditional promise in writing made by one person to another, signed by the maker, engaging to pay on demand or at a fixed or determinable future time a sum certain in money to order or to bearer. When the note is drawn to the maker's own order, it is not complete until endorsed by him. What is a check? A check is a bill of exchange drawn on a bank and payable on demand. Insurance Code. Basic concepts. What laws govern the contract of insurance? PD number 612 was amended by RA number 1067 or 10607. Special laws such as RA 1161, Social Security Act, and the Civil Code for matters not expressly provided for in number 1 and 2. What is a contract of insurance? It is an agreement whereby one undertakes for a consideration to indemnify another against loss, damage, or liability arising from an unknown or contingent event. What may be insured? Any contingent or unknown event, whether past or future, which may indemnify a person having an insurable interest or create a liability against him, may be insured against, subject to the provision of this chapter. The consent of the spouse is not necessary for the validity of an insurance policy taken out by a married person in his or her life, or that of his or her children. All rights, title, and interest in the policy of insurance taken out by an original owner on the life or health of the person insured shall automatically vest in the latter upon the death of the original owner unless otherwise provided for in the policy. What is a contingent event? A contingent event is one that is not certain to take place. An unknown past event is one which had already happened, but one is unaware if it happened or not. An unknown past event may be a designated event only in cases where it has happened already, but the parties do not know about it. That is, prior loss of a ship at sea, applicable only to marine insurance. What is a contract of suretyship? A contract of suretyship is also considered an insurance contract if made by a surety who is doing insurance business. Suretyship is an agreement whereby a party called the surety guarantees the performance by another party called the principal obligor of an obligation or undertaking in favor of a third party called the obligee. It includes official recognizances, stipulations, bonds, or undertakings issued by any company by virtue of and under the provisions of Act number 536 as amended by Act number 2206 or the Insurance Code section 177. What does doing or transacting an insurance business mean? 1. Making or proposing to make and as insurer any insurance contract, making or proposing to make, a surety, any contract of suretyship, as a vocation and not as merely incidental to any other legitimate business or activity of the surety. Number two, doing any kind of business, including a rate insurance business, specifically recognized as constituting the doing of an insurance business within the meaning of this code. Number three, doing or proposing to do any business in substance equivalent to any of the foregoing in a manner designed to evade the provisions of this code. What considerations are required in an insurance contract? General rule, an insurance business consists in undertaking for a consideration to indemnify another against loss, damage, or liability arising from an unknown or contingent event. Exception, those not formally designated as insurance businesses but are deemed doing or transacting an insurance business. The fact that no profit is derived from the making of insurance contract, agreements, or transactions, or that no separate or direct consideration is received, therefore, shall not be deemed conclusive to show that the making thereof does not constitute the doing or transacting of an insurance business. Is a protection and indemnity club considered as doing insurance business? A protection and indemnity club is an association composed of ship owners generally formed by the specific purpose of providing insurance cover against third party liabilities of its members. It is a mutual insurance association. Any contingent or unknown event, whether past or future, which may damnify or cause damage to a person having an insurable interest, or any contingent or unknown event, whether past or future, which may create a liability against the person insured. That is the subject matter. Like what risks of or perils may be insured. Can past events be insured in a marine insurance? A past event, which may be insured against, is peculiar to marine insurance. A person insured by a contract of marine insurance is presumed to have knowledge at the time of insuring of a prior loss, if the information might possibly have reached him in the usual mode of transmission and at the usual rate of communication. Give an example of a contingent liability. Reinsurance. Can the risk involved in the drawing of any lottery or for any chance or ticket in a lottery drawing a prize be insured against? The answer is no. Section 3 does not apply to risks involved in the drawing of any lottery or for any chance or ticket in a lottery drawing a prize be insured against. What are the elements of a lottery? Consideration, prices, and chance. There is no lottery where a company, to promote the sale of certain products, resorts to a scheme which envisions the giving away for free of certain prices for the purchase of said products, for the participants are not required to pay more than the usual price of the products. Here, prices can be obtained without any additional consideration. Distinguish between an insurance contract and a gambling contract. Under insurance contract, the parties seek to distribute possible loss by reason of mischance. The insurer seeks to avoid misfortune. The contract tends to equalize fortune. What one insures against is not at all the expense or at the expense of another insured person. The purchase of insurance does not create a new and therefore non existing risk of loss to the purchaser. The purchaser faces an already existing risk of economic loss. While for gambling, the parties contemplate gain through mere chance. The gambler courts fortune. The contract tends to increase the inequality of fortune. Whatever one person wins from a wager is lost by the other wagering party. As soon as the party makes a wager, he creates a risk of loss to himself where no such risk existed previously. But in both cases, one party promises to pay a given sum to the other upon the occurrence of a given future event, the promise being conditioned upon the payment of or agreement to pay a stipulated amount by the other party to the contract. In either case, one party may receive more or much more than he paid or agreed to pay. What is an insurable interest? It is an interest which the law requires the owner of an insurance policy to have in the thing or person insured. General rule, it is pecuniary in nature. A person is deemed to have an insurable interest in the subject matter insured where he has a relation or connection with or concern in it that he will derive pecuniary benefit or advantage from its preservation and will suffer pecuniary loss or damage from its destruction, termination, or injury by the happening of the event insured against. Exception. In life insurance, the expectation of benefit from the continued life of that person need not be of pecuniary nature. What are the insurable interests in different classes of insurance? In life or health, himself, of his spouse, and of his children. If a person will insure the life of another payable to himself, he must have insurable interest on the life of the person whose life he is insuring. Number two, any person in whom he depends wholly or in part for education or support, or in whom he has pecuniary interest. No persons obliged to support each other. Any person under a legal obligation to him for the payment of money or respecting property or services of which death or illness might delay or prevent the performance. And note, a creditor may insure his debtor's life for the purpose of protecting his death, but only to the extent of the amount of the debt and the cost of carrying the insurance on the debtor's life. Any person upon whose life any estate or interest vested in him depends. Distinguish between life insurance policy and civil donation. Life insurance policy, this is also founded on liberality, as the beneficiary will receive the proceeds of the said insurance. Civil donation, on the other hand, is an act of liberality whereby a person disposes gratuitously a thing or right in favor of another who accepts it. As a consequence, the proscription in Civil Code Article 739 should equally operate in life insurance contracts. Who is the beneficiary? A person who is named or designated in a contract of life, health, or accident insurance as the one who is to receive the benefit, which become payable according to the terms of the contract upon the death of the insured. Who can be designated as beneficiary? General rule: when one insures his own life, he may designate any person as the beneficiary, whether or not the beneficiary has an insurable interest in the life of the insured. Exception: persons specified in Article 17739 of the Civil Code cannot be designated. 1. Those made between persons who are guilty of adultery or concubinage. Conviction is not a condition precedent. Letter B. Those made between persons found guilty of the same criminal offense in consideration thereof. And 3. Those made to a public officer or his wife, descendants or ascendants by reason of his office. In order for Article 739 to apply, it is not required that there be a previous conviction for adultery or concubinage due to the wording of preponderance of evidence. Hey, watch out for part 2.